Lance Roberts,
How do you do?
Mark Smith, Raven Sword, Dee Dee Robinson, Catherine Miller, Matt Line,
How do you do?
Mark Stan. See, make yourself comfortable. You know, Mike, we know it runs in the family, but tell us why you would like to be a judge.
Well, it isn't because it runs in the family. Somebody did say something to me about, well, you want to go into the family business. That really isn't it. But, you know, a couple of things that I have learned from my father and from my brother is that being a judge really is about the highest office to which a lawyer can aspire. And I think it is natural to want to go to the highest office to which a judge can, or to which a lawyer can aspire. Just like if you're a surgeon, you probably want to work at the Mayo Clinic or Johns Hopkins. One of the things that I realized when I was preparing my application and going through all of my employment history was that everyone who has ever hired me for a legal position has gone on to be a judge or was a judge in the past. And that is starting with my first clerkship in Ocala to my clerkship at Carlton Fields, being an associate at Carlton Fields, to working with David Monaco at Monaco Smith, Hood and Perkins, and with Terry Perkins as well. And even my current partner, John Upchurch, was a circuit judge in the past. And so what I came to realize was that the people I have looked to as mentors outside of the quote-unquote family business are people who have had the qualities and have had the desire to go on to the bench. And those are the people who I have tried to pattern my legal career after and who I've tried to emulate. And so in a way, it seems natural outside of any family activity that that's where I would lean.
Mike, you're spending a lot of time as a mediator, currently do that.
Yes.
And the seat is currently for a family law seat, but it could be civil, it could be criminal. Judge Perkins will make that determination based upon a number of factors. Can you talk about how your experience as a mediator would prepare you for whatever it is, the discipline, so to speak?
Well, I've been very fortunate because I have had two different phases of one career, one as an advocate and one as a neutral. Now, as a neutral, I've been both a mediator and an arbitrator. My experience as an arbitrator would, I think, equip me to handle any division as far as process is concerned. Now, if you put me in a family division or a criminal division, do I have a substantive learning curve? Yes, I do. But one of the things that we learn as mediators and arbitrators, and it is both taught and learned in practice, is to acquire the temperament and to acquire the patience that is required to get the job done. And it's not just listening. It's not just giving people the opportunity to be heard. That's the procedural part of it. But it's also important to listen to them and make sure that the litigants and the lawyers understand that they have been listened to. And that's what I strive to do. As a mediator, I can be somewhat quiet because I'm listening. And I want people to understand that anything they hear from me is a reflection of what they are telling me. But I try never to get ruffled in a mediation, certainly not in an arbitration. I can see past the static, the emotional static of the parties, past the emotional static of the lawyers, all of the posture. And I think those skills translate directly to the bench.
Mike, tell us about the first phase of your legal career when you were an advocate, your experience in what areas?
Well, at Carlton Fields, I was in the litigation department, and that was, those first couple of years, I spent a lot of time doing what I was told. And that would entail, yes, commercial litigation, and I got some trial experience, a little bit of jury experience, some non-jury experience in the commercial arena. But I also did the sorts of things that initial year associates would do, like go to warehouses and look through boxes of documents and things of that nature. And when I came to Daytona Beach and joined the Monaco Smith firm, I still stayed in what was called commercial litigation in the general sense, but I got a very good piece of advice early on from David Monaco, who said, learn everything you can about real estate, because real estate is what drives Florida's economy, and it's what drives litigation in Florida. And so I started learning and working with him on eminent domain cases, construction cases, title insurance claims, anything that had to do with real estate. I also had the opportunity to work with now Judge Perkins on insurance defense matters because I wanted to learn that area of the law as well. My thought was to become a generalist. In a community like Daytona Beach, I thought that would be most helpful. And so I wanted to learn a little about a lot. And that way I could learn a lot about something when I needed to, as the case required. So as a result, you know, I also drafted wills for people, probated estates. I can draft, could draft leases and contracts. Really, whatever it required, whatever the client required, with the knowledge that I had partners and peers to work with and make sure that we were doing everything correctly. But my goal was always to be a generalist, but with a focus on litigation.
I have pass on a compliment and then raise a concern. I have the privilege of vetting you, and I got to tell you, everyone I talk to, and then people calling me out of the blue, and people I was calling other candidates were praising your intellect. And so I think your intellect is a strong suit of yours, and you deserve to know that it is well admired in this community.
Thank you.
I appear before judges, and a lot of judges seem to want to be mediators and to split babies and to send me to mediation. And has this been mediated? Can I go back to mediation? And can I craft a result that gives everyone a little bit of something? And sometimes that is not the way the law works or should work. And there needs to be a winner and a loser, and there's an outcome that may be dictated by the law. How will you shed your mediator skin of crafting a result everyone can live with when there needs to be a clear winner and a loser in the case?
Here's what I tell people in mediation. I tell them that every lawsuit is a story. That's why people like lawyer books. That's why John Grisham is a zillionaire. And that their particular case is a story whose ending has not yet been written. And we have two potential authors. They can do it themselves, or they can have the court do it. And in all likelihood, depending on who they choose, they're going to have drastically different endings because the function of the court is to conduct the formalized debate we call a trial and determine who is the winner and who is the loser. And from that, the judge can say, well, all right, the law says I can do A, B, and C, so okay, I'll do A and B. And that's as far as the judge can go. The judge can only do what the law says the judge can do, whereas the parties in a mediation can do anything they want so long as the law doesn't prohibit it. And so what I try to impress upon people is that they have the ability to do an awful lot of things at the price of compromise that the court can't do. And you know,
I think
having
sometimes judges want to do the judges see, oh, there's a great compromise for you guys, and I want to guide you there, but I don't know if that's the judge's role or not, and I wonder what your thoughts on that.
I don't think that is the judge's role. The judge's role, up until the time of trial, is to some extent case management, and to make sure that if there's an ADR requirement, whether it's mediation, non-binding arbitration, binding arbitration, that it is carried out. But you can't deprive parties who say, look, I want a judge to tell me, or a jury to tell me what the answer is. You can't deprive them of that right. They always have it. And you know, having told people this hundreds and hundreds of times, I don't think it's something I forget.
Mike, I know with your practice and your experience, you're used to dealing with more sophisticated parties. There is potential, obviously, that this docket may be a family law docket that also includes a lot of pro se individuals. How would that, if anything, change your presentation, and how would you deal with having an unrepresented party having to spar with an attorney? Are you going to lower the standards? How are you going to deal with that?
I think everyone has to be treated with civility and respect. That starts with the judge. And I think that that is something that will breed reciprocal civility and respect. The pro se litigants, if you're talking about the truly uneven playing field, when you have a lawyer on one side and a pro se litigant on the other, you can't lower the evidentiary standard. You know, they still have to prove whatever they have to prove by whatever burden they have. One thing I have seen judges do is, and I don't know if this is really the right thing to do or not, is that they will try to make their decisions somewhat bulletproof on appeal by letting a pro se party or even a lawyer who is hopelessly outgunned get everything into evidence that they want, so that there's no complaint that the judge didn't consider something. I don't know that that's the right approach. What I do think, the best thing to do with pro se folks is to make sure that they utilize whatever self-help resources are available through the court system. There is low cost, or sometimes no cost mediation services available. It would seem to me that when you have a pro se litigant or two pro se litigants involved, at least in a family division, you probably aren't talking about equitable distribution to the extent that you would be talking about things like child support and parental responsibility and things like that. So I would want to see them winnow out as many issues as they could, whether it's through ADR or not, before they come in to use what is inevitably limited court time. It's a roundabout way of answering the question, and it may be because there's really not a satisfactory answer to it.
You answered my question. It's just one of those things where you would like to know what your approach would be, because I know that that's not necessarily something that you're used to dealing with, but there's a possibility that you would have to address that issue, and I would like to know, as an law practitioner, how you would handle that.
Well, I do deal with people who are not necessarily what you would call sophisticated. My mediation practice, while it is primarily commercial in nature, but it also encompasses probate, it encompasses some personal injury, it encompasses real estate. And, you know, anybody can get in a real estate dispute. You know, neighbors fight all the time. They don't have to have any particular degree of sophistication. Small business owners, you know, self-made people, they don't have advanced degrees on the wall, necessarily. What they have is a work ethic and horse sense. And, you know, they are worthy of the same consideration as anybody who can hire a X $100 an hour lawyer.
One question, I see you've been applying this every time you apply for a judgeship, but it's been 10 years. Why have you waited 10 years to apply for a judgeship?
The last time I applied was in the middle of 2003. And at that time, I was starting to do some more mediation. After I got the unhappy call the third time that I was not selected for the spot, not long after that, I had the opportunity to become a shareholder of Church Watson and Max. And since I enjoyed what I was doing, as far as being a mediator, I took it. And it seemed to me that I should give that X number of years to build that practice, refine those skills, and lay out of pursuing a judgeship while I did that.
Why do you think you got that unhappy call this time? Politics?
I have no idea. I mean, it's not, I'm not so naive as to say that politics is not a part of how the decision gets made. But what factors go into the decision ultimately, I don't know. I was pleased that every time somebody who I thought was especially qualified got selected. It's not as if I went, oh my gosh, how could they have not picked me? But you know, I will admit that as that 60-day clock gets closer and closer to the end, you do sort of start mentally picturing yourself in the job. But the call was not the call I wanted, but it wasn't the end of the world. It has opened up a whole new aspect of my career that I really wouldn't trade for anything.
Mike, thank you for coming in. We'll
Thank you.
be making our decision by the end of the day, and we will let the lady hall applicants know whether to run the list or not immediately.
All right, thank you very much.